Hello, good evening, everyone. I'm coming at y'all with an update in Blake Lively and Justin Baldoni case. Um, and here we go. This is the update in Blake Lively and Justin Baldoni case.
By the judge, the New York Times is trying every which way to get out of the case. Lively is also hiring a former CIA alum, and a co-star is speaking out. A lot of updates we got to get to when it comes to the ongoing legal saga of Justin Baldoni versus Blake Lively. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Okay, so we got a bunch of new updates we got to talk about in the Baldoni-Lively legal fight. Haven't talked about it in a minute. So remember, Lively has sued Baldoni, her co-star director of It Ends With Us, his production company, Wayfarer executives, his PR and crisis management experts, his team, alleging that Baldoni sexually harassed her and then launched a retaliatory smear campaign against her. And then Baldoni fired back in a lawsuit of his own against Blake Lively, her husband Ryan Reynolds, also suing the New York Times, arguing there was a coordinated effort to destroy his reputation with false allegations that were weaponized against him for Lively to take control over the movie, take control over all aspects of production. That's more of a generalized summary, but at this point I'm sure all of you know the back and forth. Okay, now we got to go into the updates. First up, we're going to start with the fact that Blake Lively was just delivered a blow by the court. Now, if you've been following us here on Sidebar, you may remember that whole subpoenas issue we talked about. It was reported several weeks ago that Lively's legal team sent out a bunch of subpoenas to cellular provider companies like AT&T, Verizon, T-Mobile. Her attorneys, Ezra Hudson and Michael Gottlieb, said in a statement that was published in The Hollywood Reporter, quote, Miss Lively has initiated discovery that will expose the people, tactics, and methods that have worked to destroy and bury her reputation and family over the past year. We will now receive all of the receipts that, unsurprisingly, are nowhere to be found on Mr. Friedman's website. And like Miss Lively, those receipts will have their day in court. And that is a reference to Baldoni's attorney, Brian Friedman, and the website that was purportedly launched by him and Baldoni's team, featuring an amended complaint in the case, their version of a timeline of events in the story. It featured never before seen text messages between Baldoni and Lively and Baldoni and Reynolds. Now, the lawyers for Baldoni and Co., they filed a letter with the judge. And so when it came time
Sorry
for
about
installation
that.
day, what are your thoughts about the... Now, the lawyers for Baldoni and Co., they filed a letter with the judge overseeing this case, the Honorable Louis J. Lyman, and they argued that these subpoenas from Blake Lively, they are way too overbroad. They claim that Lively was seeking, quote, all documents concerning ingoing and ongoing calls or text messages related to phone number, and it's redacted, belonging to each of the individuals, Wayfair parties, some of their employees, various non-party individuals, including but not limited to call logs, text logs, data logs, and cell site location information. They argued that the subpoenas seek such information over a period of multiple years, in most cases spanning from December 1st, 2022 to the present. When they wrote in their letter to the judge, it is hard to overstate how broad, invasive, and atypical these subpoenas truly are. This is civil litigation, not a criminal prosecution, and the Lively parties are not the FBI. Yet the subpoenas seek not only the complete call and text history of each of the targets over a period of several years, no matter the sender, recipient, or subject matter, but also over the same period, real-time location information and data logs reflecting, among other things, web browsing history. This would include, of course, materials protected from disclosure by a laundry list of statutes and privileges, among them the attorney-client privilege, the spousal privilege, and the physician-patient privilege. Moreover, the information sought by the subpoenas is widely disproportionate to the needs of the case and unnecessarily invades the privacy of untold numbers of third parties, including family, friends, business partners, and quite literally any other person with whom any of the targets have communicated with over a period of years. And they called this, quote, a flagrant abuse of the discovery process. So they had a major issue with these subpoenas.
Okay.
Now, Blake Lively's side responded, and they argued
So in
in
other
their
words,
letter
they
to the
just
court, quote,
they
the
still
Wayfair
slinging
parties have
mud.
sued Miss Lively for a preposterous sum of $400 million for claiming that a retaliatory campaign existed, yet now appear to fear having third parties turn over the actual evidence that would document the who, what, when, where, and why of that campaign. On February 12, 2025, the Lively Reynolds parties issued notices of the subpoenas to the aforementioned carriers seeking
they still slinging
non-content
mud.
records, that is, numerical logs related to 15 specific individuals. Each individual is either a party to this action or is an agent, employee of a party who appears, based on evidence discovered in this case, to have a direct connection to the underlying issues. The requests are tailored to the time during which evidence shows each individual may have been involved in acts giving rise to Miss Lively's claims. Such information is not only relevant, but essential to unearth the network of individuals involved in the alleged retaliation scheme against Miss Lively. And to add a bit more to that, later on, it is emphasized a bit more, quote, the Wayfair parties misrepresent both the nature and the scope of the subpoenas, inaccurately stating that they
So in other words, they're
spousal
gonna drag this
communications,
out.
medical information, attorney-client communications, among other things that could infringe on privilege. The requests do not seek the content of any communication, only call, text, and data logs. The Reynolds parties have not sought and do not seek here anything other than non-content records as permitted by law. The Wayfair parties have cited no authority from any court in any jurisdiction to suggest that such subpoenas would be improper. And they are that this type of information, namely, identifying information or something, proving something exists or proving a conversation happened, that is not protected by privilege. And then again, it's not the context of the communications that they're seeking right now. They argue that Baldoni, Wayfair, they have not explained how any of that information they're looking for implicates any medical privacy issues. By the way, not to take away from this in any way, but I did want to tell you about something real quick. Kind of an important issue that is affecting a lot of people. Dandruff. Now, most people assume it's from a dry scalp, but it's actually caused by an overgrowth of fungus called Malassezia. And that fungus, it feeds on the oils inside most shampoos, even some of the ones from dermatologists.
Why are we talking about
That is where
dandruff?
our amazing sponsor, Dermazen.
Okay.
So Dermazen, clinically tested overnight serum, has a
I'm sitting there trying to figure out why he talk about dandruff, and come and find out that he's got a plug of shampoo.
92% success rate and nearly 3,000 positive testimonies. So while you sleep, it disrupts the biofilm around the fungus, which most dandruff shampoos never touch. So you can target flakes at the source. And right now, you can get their scalp relief system for an extra 10% off plus free shipping. And that includes the overnight serum, the dermatologist recommended shampoo, a scalp scrubber to clear buildup, boost circulation. So experience flake-free confidence every day. Go to dermazen.com/sidebar for an extra 10% off and free shipping, or tap the link below and get yours today.
So South Carolina probably just did the coolest thing I've seen any state do in a while. So if you live in a South Carolina zip code and you're a resident here, you can now officially apply to have your auto insurance rates reduced significantly as long as you've had 0 DUIs in the last 5 years, and it costs nothing to claim this. The big auto insurance carriers don't want...
Or tap the link below and get yours today. And finally, Lively's counsel addresses another point. Wayfair's argument that third parties' privacy concerns could be impacted by these subpoenas. Well, Lively's counsel argues that doesn't work because Wayfair and the other parties, they don't have any authority to make that objection. That's up to the third parties to stand up and say so. They have no claim or interest in those communications. We call them the law standing. Essentially, they have no standing to make that objection, that they're not the ones being potentially harmed or affected. That's the third parties and the non-parties in this case. If they have a problem, they should object. And Lively's lawyers also argued that if Baldoni & Co. had legitimate concerns here, why not move quickly to put a protective order in place? Okay, so what did the judge just decide? Remember I said Blake Lively was just handed a loss? Well, the judge ordered that Baldoni & Co., their motion, should be granted in part and also denied in part. Let me explain. So the first thing the judge did was explain that there's been an update in this case, and that was that after the parties, both sides, met and conferred, Lively actually agreed to narrow her subpoenas. She agreed to remove the reference to all documents, she agreed to remove the request for locational data, and she agreed to clarify that the subpoenas seek only call logs and text logs reflecting non-content numerical information regarding ingoing and outgoing text messages. and that Lively has prepared updated, modified subpoenas with these changes. However, apparently, Baldoni and Wayfarer, they continued to object to the subpoenas, arguing that the subpoenas will improperly reveal the phone numbers of anyone with whom they communicated, whether it was related to this case or not. So they countered that the subpoenas should only be limited to communications between the phone numbers and the phone numbers of parties in the case and witnesses that Lively intends to call at trial. And it seems the judge has agreed with Justin Baldoni and Wayfarer & Co., writing in his order, quote, "The subpoenas of the Wayfarer parties' phone records, even as modified after the meet and confer, are overly intrusive and disproportionate to the needs of the case. The subpoenas request call and text logs between certain of the Wayfarer parties and any other phone number, in most cases from December 1st, 2022 to the present. This request implicates legitimate privacy interests. Even though Lively has narrowed her request to exclude the content of calls or messages, the phone records themselves would still contain sensitive information."
Okay, here's my question. How can you throw out the text messages, the text message and the phone calls when it's part of the case? That doesn't make sense.
Regarding which doctors, psychologists, or acquaintances the Wayfarer party spoke to and when. And the judge found that Lively hasn't shown how she would actually separate those numbers that may be relevant to the case from those that wouldn't. And the judge doubled down that even if someone doesn't have a privacy interest, let's say under the Fourth Amendment, protection against unreasonable searches and seizures, parties still have a privacy interest in their phone records under state or federal law. And Baldoni, Wayfarer, they have a privacy interest in their communications with non-parties. And another problem cited by the court is that while Lively argues the subpoenas will show who was a part of the alleged smear campaign against her, the problem is the alleged negative campaign didn't start until August of 2024. So why would Blake Lively need communications in 2022 and 2023? And then the judge writes, quote, "Lively has not provided a basis to believe that the broad discovery she seeks will reveal information regarding unknown participants in the negative media campaign proportionate to the burden on the Wayfarer party's privacy interests." So the subpoenas are thrown out regarding the extent they seek phone records of Wayfarer parties. But that doesn't mean this is a total win for Justin Baldoni and Co. Why? Because the judge indicated that Lively could make discovery requests for more specific evidence and information tailored to specific people in the case, basically meaning be more specific, be more precise about what you're looking for. And, Blake Lively, you may be able to get what you want, but also the judge sided with Blake Lively's argument that Baldoni, Wayfarer, they don't have standing, they don't have the legal authority to object to the subpoena request for phone records of non-parties, meaning, again, they don't have standing to object. So in other words, Baldoni, Wayfarer, you may have a privacy interest in your own phone records, but they haven't provided any basis for why they have some sort of interest or privacy interest in the communications of non-parties. So the Wayfarer-Baldoni motion to quash the subpoenas for that information was denied. Lively won that one. But we got a response from Brian Friedman in a statement to Fox News Digital. It says, "The court put a stop to Miss Lively's egregious attempt to invade our client's privacy. This is a big win. No matter how the Lively parties may try to spin this decision, the court saw their efforts for what they really are, a desperate fishing expedition intended to salvage their debunked claims long after they already savaged our client's reputation in the news."
I was gonna play this whole thing, but it ain't no point in me playing this out. Basically, Blake Lively and Justin Baldoni are gonna drag this out till whichever one of them gets tired. And that's it, and that's all. Like I said, you can go log crime and go through the whole thing. I'm not gonna do it because honestly, it's just pointless.